So in this session today, I'm going to talk to you about certain very important legal developments, which is absolutely important from the point of view of your examination. Now, this session will help you in scoring better, in scoring better insofar as this examination is concerned. I'm going to talk to you about some important legal developments. So let's begin. The first one is, in a landmark judgment, the Supreme Court of India has said that what is a quo warranto writ? Now, what is a quo warranto writ? By whose warrant have you been appointed? Now, if a person, a public office holder, is appointed without following the due process of law, if a person is not eligible, if a person is not eligible for a particular post and he is appointed, the Supreme Court can very well quash such an appointment. That is the meaning of quo warranto. So quo warranto is a writ which can be issued by the High Court under 226 as well as by the Supreme Court under 32, whereby if a person is appointed in a particular position, it has to be some public office, and he does not have the required qualification for that, then such an appointment can be quashed. Now let's see what happened. Now under Article 226, of the Indian Constitution, the High Court has the power to issue a writ of quo warranto. Under Article 226, the High Court has the power to issue a writ of quo warranto. When can it issue? It can issue where an appointment has not been made in accordance with law. So if an appointment to a public office is not made according to law, such an appointment can be quashed. Let's see what happened. Now, the Supreme Court upheld the Calcutta High Court's decision of setting aside the state of West Bengal's decision to reappoint Sonali Chakravarti Banerjee as Vice Chancellor of the Calcutta University. Now, the delinquent, Mrs. Banerjee, was the Vice Chancellor of Calcutta University. Now, who under the law can reappoint her? The Chancellor. Who is the Chancellor? The Governor. Now, can the state take the power of the Governor and appoint and reappoint the Vice Chancellor? The Calcutta High Court said, no, you cannot do that. The power of appointment, including reappointment, is entrusted with the Chancellor and not the state government. And so the state government could not have issued the order reappointing the Vice Chancellor. Am I clear, all of you? The power is given to the Chancellor to reappoint a Vice Chancellor. Under the law, the power is given to whom? Chancellor. The Chancellor did not act on it. Who acted? The state government. Now, does the state government have the power to do so? The answer is no. Henceforth, her appointment was struck down. Let's see what the Chief Justice of India presently had to say about this. The government cannot misuse the removal of difficulty clause to remove all obstacles in his path which arise due to statutory restrictions. allowing such action would be antithetical to the rule of law. Misusing the limited power granted to make minor adoptions and peripheral adjustment in a statute for making its implementation effective to step up the provisions of the statute altogether would defeat the purpose of the legislation. Now, this is very, very, very important and crucial. The Supreme Court says where there is a specific provision, it is not open for the state government to conjure up a lacuna or omission and purportedly exercise the power to remove difficulty. So the power to reappoint, the power to reappoint the vice chancellor is given to the chancellor. So the government cannot usurp the power of the chancellor. Is that clear? Am I clear, all of you? Is that clear to each and every one of you? Tell me. Is that clear to each and every one? That is what we understand by quo warranto. Quo warranto is that writ which the High Court and the Supreme Court can use where an appointment to a public office is not made according to the rules and according to law. Okay? Everyone? Okay? The next important judgment, the next important legal development. The Supreme Court of India has given a split verdict on the hijab case. Now, what is this hijab case? Certain women belonging to the Muslim community wanted to attend schools, wanted to attend colleges wearing hijab. Now, the thing is this, there is a circular that was issued by the state of Karnataka stating that women cannot enter school or colleges wearing a hijab. Now, that particular rule was challenged in the Karnataka High Court. The Karnataka High Court says that wearing hijab is not a part of the essential religious practices of Islam, and hence the state government can prohibit a student from wearing hijab from entering school, from entering college, from entering educational institution. That was the ambit of this particular thing, the particular judgment of the Karnataka High Court. So the Karnataka High Court played a very important role while deciding this issue. The Karnataka High Court simply said, wearing hijab is not an essential practice of Islam. It is not protected under Article 25 of the Indian Constitution, and therefore, a woman belonging to the Muslim community cannot wear hijab in educational institution. Now, this particular judgment came to be challenged in the Supreme Court. Now, before I deal with the judgment of the Supreme Court, and I tell you, there were two judges, Justice Hemant Gupta and Justice Sudhanshu Dhulia. There were two different opinions given by the two judges, learned judges. First, let's see Article 25 of the Indian Constitution. Article 25 of the Indian Constitution says that subject to public order, morality, health, and to the other provisions of this part 3, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. So every individual, subject to public order, morality, and health, can practice freely, can profess freely, can propagate his religion freely. That is what Article 25 categorically says. Now, as I told you that the Karnataka High Court judgment came to be challenged in the Supreme Court. There were two learned judges, Justice Hemant Gupta, retired. Very recently, Justice Gupta retired. And we had Justice Sudhanshu Dhulia. Let's see what the two judges said. Now, let me give you a brief outline of what the judges said. Justice Hemant Gupta says that the restriction on wearing hijab in schools, colleges is perfect, is right. He says that secularism is a concept applicable to all citizens, and permitting one of the religious communities to wear religious symbol of their community would be considered against secularism. Now, my question over here is, what about the Sikh community? The Sikh community wear those pagadis and go to schools and colleges. Now, here Justice Hemant Gupta says that if you are allowing one community people to enter into educational institution with religious symbol, it is opposed to secularism. Now, what is secularism then? Now, a Hindu might wear a tika and go to school. Now, I am sure that most of you have this practice that before you go for your examination, your mother or your grandmother will call you and put a tika. Hindus. Is it not so? Now, think that way. Now, if the Muslim people are not allowed to wear hijab, you can wear a tika. A Sikh community person can wear the turban. No issues. Then, is that clear? Are you able to understand, guys? Are you able to understand? Now, this is what Justice Hemant Gupta said. That if you are allowing the Muslim community people to wear hijab, it is anti-secularism. It is anti-secularism. Am I clear, all of you? Am I clear to each and every one of you? Please tell me. Am I clear to each and every one of you? Any doubt? Okay. Did you all understand, all of you who are watching me? Are you understanding or not? Tell me. Okay. Justice Hemant Gupta says that the restriction on wearing hijab in educational institution is perfectly good, and secularism is a concept applicable to all citizens. If you are allowing one particular community to wear a symbol of their community or their religion, it would be against the concept of secularism. The interpretation by the believers of the faith about wearing a headscarf, hijab, is the belief or faith of an individual. Religious belief cannot be carried to a secular school maintained out of state fund. It is open to the students to carry out their faith in a school which permits them to wear hijab or any mark, maybe a tilak, which can be identified to a person holding a particular religion, belief, but the state is within its jurisdiction to direct that the apparent symbol of religious belief cannot be carried to schools maintained by state from the state funds. Thus, the practice of wearing hijab could be restricted by the state in terms of a government order. Now, can the state tomorrow say that, okay, people cannot wear turban and enter schools and colleges? If that be so, then there will be one particular community who cannot attend schools and colleges. Understand this. Then there will be one particular community, the Sikh community, who cannot get proper education then. If the reasoning is so, am I clear, all of you? Am I clear, everyone? Every one of you. Now, Justice Dhulia has set aside the judgment of the Karnataka High Court and said that hijab ban is a violation of fundamental right under Article 19(1)(a), freedom of speech and expression, and 21(a), right to education. Now, right to education is provided under Article 21(a) of the Constitution. Now, if you are stopping a person from wearing hijab and you are saying that if you wear a hijab, you cannot enter the school, then that amounts to a violation of right to education, which is enshrined under Part 3 of the Indian Constitution. Am I clear? Am I clear, everyone? Is that clear to each and every one of you? Tell me that. Okay? Okay, that's great. That's great. Justice Sudhanshu Dhulia says that school is a public place. Yet drawing a parallel between a school and a jail or a military camp is not correct. Again, if the point which was being made by the High Court was regarding discipline of a school, then that must be accepted. It is necessary to have discipline in school, but discipline not at the cost of freedom, not at the cost of dignity. Asking a pre-university schoolgirl to take off her hijab at her school gate is an invasion on her privacy and dignity. It is clearly violative of the fundamental rights enshrined under 19(1)(a), 21 of the Indian Constitution. Right to her dignity and her privacy she carries in her person, even inside her school gate or when she is in her classroom. It is still her fundamental right, not a derivative right as has been described by the High Court. So that is the opinion of Justice Sudhanshu Dhulia. Am I clear? Now, in the present situation, since there are two different views, two divergent views by two learned judges, the matter has been placed before the Chief Justice of India, Justice D.Y. Chandrachud, to constitute an appropriate bench of larger strength to discuss on this issue and deliberate upon this issue so that we have a final judgment in this particular issue at hand. Am I clear? Moving on. The Supreme Court has upheld the 10% quota for the EWS admissions in schools and colleges and in government job by a constitution bench of the Supreme Court, 3:2 split verdict. The Supreme Court has upheld the 10% quota for the economically weaker section of the society. Now, what is this EWS? Now, EWS is the economically weaker section of the society. The objective was to provide reservation to the economically weaker section of the society in jobs and higher education. Now, this 10% reservation is given to people who are not covered under the existing reservation. Now, you have SC, ST, OBC and other reservation. Those people who are not covered under these reservation, they get a 10% reservation. Now, the 124th Amendment Bill was passed by the Parliament, providing reservation in public employment, higher education to the weaker section. Now, after this 124th Amendment Bill was passed and it got the approval of the President, it became the 103rd Constitutional Amendment Act and it was passed. Now, what did the court say? Now, there are three judges who said that this law is absolutely valid, and there were two judges who said that this law is not valid. Reservation structured singularly on economic criteria does not violate the essential features of the Indian Constitution and does not cause any damage to the basic structure of the Constitution of India. That is what the Supreme Court had said. The Supreme Court said that reservation based on economic criteria is not violative of the basic structure. Exclusion of the classes covered under Article 15.4 and 15.5 and 16.4 of the Constitution from getting any benefit of the reservation as economically weaker section is done to balance the requirement of non-discrimination and compensatory discrimination. So the Supreme Court said that people who are backward, they already are getting some amount of reservation. But what about those who require but they are not getting? Yes. Justice Dinesh Maheshwari said, reservation is an instrument of affirmative action by the state so as to ensure all inclusive march toward the goal of an egalitarian society which countenance inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantageous as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate the essential features of the Constitution and does not cause any damage to the basic structure of the Constitution of India. So, reservation that is based on economic criteria, does not violate the basic features, the basic structure of the Indian Constitution. Justice Dinesh Maheshwari further said that reservation for economically weaker section up to 10% in addition to the existing reservation does not violate the basic features of the Indian Constitution, nor does it cause any damage to the basic feature of the Indian Constitution on amount of the breach of this 50% ceiling. Now, in Indra Sahani versus Union of India, the Supreme Court said that the maximum amount of reservation in a particular given circumstances cannot exceed 50%. Now, there are states where you have reservation up to 70% to 79%. The Supreme Court, in this particular judgment, in this Constitution Bench judgment, has said that yes, the 10% reservation that is provided, even if it breaches the Indra Sahani judgment of 50%, it is valid. Justice Bela Trivedi said that, however, at the end of 75 years of our independence, we need to revisit the system of reservation in the larger interest of the society as a whole, as a step forward towards transformative constitutionalism. So Justice Bela Trivedi, her ladyship, very categorically said that it is right time that we revisit this entire reservation system in India, because we have to transform our society. We need to transform our constitutionalism. Then you have Justice J.B. Pardiwal, who said that the real solution, however, lies in eliminating the clause that we have led to social, economic, and educational backwardness of the weaker section of the community. This exercise of eliminating the causes started immediately after independence, almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tampering the gap between the classes to a considerable extent. As larger percentage of backward classes members attain acceptable standards of education and employment, they should be removed from the backward category so that the attention can be paid towards those classes who genuinely need help. So this is some new philosophy that is coming from the Supreme Court, saying that those people who have come out of backwardness should be removed from giving reservation. Furthermore, Justice J.B. Pardiwal says that in such circumstances, it is very much necessary to take into review the method of identification and the ways of determining backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's condition. The idea of Baba Sahab Ambedkar was to bring social harmony by introducing reservation for 10 years only. However, it still continues past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest. Now, the judges understand that reservation has become a vote bank politics today. Dr. B.R. Ambedkar's philosophy was, let's have reservation only for a period of 10 years. It still continues even after 7 decades. On the dissenting note, the Chief Justice, the former Chief Justice of India, Justice U. Lalit and Justice Ravinder Bhatt, said that economic criteria per se, that means reservation on economic criteria, is per se permissible in relation to access of public good. The same is not true for Article 16, the goal of which is empowerment through representation of a community. This is very, very important. The court has, for the first time in 7 decades of republic, sanctioned an exclusionary and discriminatory principle. Our constitution does not speak the language of exclusion. In my considered opinion, the amendment is the language of exclusion, violates the principles of justice and thereby the basic structure. Now, what did Justice U. Lalit and Justice Ravinder Bhatt say? Justice U. Lalit and Justice Ravinder Bhatt simply says that this 10% reservation is not applicable to SC, ST, OBC. That means the SC, ST, OBC who are generally backward, they are excluded from this EWS reservation. Now, Can you exclude a criteria of people from the reservation? No. And hence it hits the basic structure owing to the fact that it believes on exclusion. Is that clear, everyone? Am I clear to each and every one of you? Okay. So guys, if you are liking this session, do press the like button. If you are liking this session, do press the like button, guys. Okay. Okay. Now, the 103rd constitutional amendment does not breach the basic structure of the constitution, permitting the state to make special provision for reservation on economic criteria, permitting the state to make special provision in so far as admission to private uneducated institutions is concerned, in excluding the socially and educationally backward classes, OBC, STs, and STs from the scope of EWS reservation. These are the very, very important outcome of this EWS judgment. Okay? You can take a screenshot of it because it is very, very important for each and every one of you. Okay. Okay, so what is this 103rd constitutional amendment? Nothing in this article shall prevent the state from making any provision for the reservation or appointment of the post in favor of economically weaker section of citizens. Other than, very, very important, other than classes like SCBCs, STs, OBCs. So people who are not covered under SC, ST, OBCs, SCBCs, will get a 10% reservation if they qualify the economic criteria. Okay, is that clear? Let's have certain questions. The first question is up there on your screen. Where is the headquarter of the International Commission of Jurists located? Where is the headquarter of the International Commission of Jurists? Tell me fast, all of you. It is located at Geneva. Very good, very good, very good. Geneva. It is located, its headquarter is in Geneva, Switzerland. Am I clear? Everyone, everyone. Very, very important questions. You might get some of these in your question paper. So pay absolute attention to these questions that are coming. The next one. Which of the following amendment provided constitutional status to cooperative societies? Let's see. To the cooperative societies. Okay. It is the, which one? Tell me, fast, fast. 97th constitutional amendment. It is the 97th constitutional amendment. Is that clear? Everyone? The next one. Okay. Very important. Which state government recently decided that no Gorkha citizen will be prosecuted under the CAA? Which state government said that the Gorkha people will never be prosecuted under the Citizenship Amendment Act? Manipur, Sikkim, Assam, Nagaland. I want everyone to answer this question. Correct answer is Assam. The Assam cabinet has very categorically decided that no cases will be registered insofar as the Citizenship Amendment Act is concerned for the Gorkha community. For the Gorkha community. Question number 4. Who amongst the following is the only Chief Justice of India to be appointed as governor of a state? U. Lalit, D.Y. Chandrachud, P. Sathasivam, Deepak Mishra. Justice Lalit, Justice Chandrachud, Justice Sathasivam, Justice Deepak Mishra. Who amongst the following is the only Chief Justice to have been appointed as the governor of the state? Justice U. Lalit, just retired. If he was appointed as a governor, you would have come to know. Justice Chandrachud is the present Chief Justice of India. Now the question is it Justice Sathasivam or Justice Deepak Mishra? And the correct answer is Justice Sathasivam. He was appointed as the governor of Kerala. Okay. The 48th Chief Justice of India was the first judge to have been appointed as a governor of a state. Is that clear, everyone? Is that clear? Justice P. Sathasivam. Very good. So guys, if you are liking this session, do press the like button and share this session with your friends. Okay. The Indian Constitution borrowed its idea of preamble from which country? US, Canada, Japan, South Africa. US, Canada, Japan, or South Africa? The Indian Constitution borrowed the ideals of preamble from which country? Is it United States of America? Is it Canada? Is it Japan? Or is it South Africa? And the correct answer is, tell me fast, it is United States of America. It is. Now, US Constitution also has a preamble. We also have a preamble. So the idea of having a preamble to the Constitution came from the US Constitution. Okay? Is that clear? Okay. So guys, with this, we come to the end of this session. Thank you very, very much. I hope you understood the session. Please like this session. Do share this session with your friends. Do join our Telegram channel. Do like our page on our Instagram. And definitely do not forget to download the BYJU'S Exam Prep app. Now, one very important announcement is this, that on 11th, we will have a session on the live analysis of ELIT, and on 18th, we will have it on CLAT. So, 11th, stick on to our YouTube channel wherein we will discuss ELIT, and on 18th, we will have an analysis of CLAT. Thank you very, very much. God bless you. Thank you. Bye-bye. Take care. See you. All the best.